Hi, Lee. Nice to see you again in a better setting.
You too.
No, I just messaged you when we were in the breakout. I mean, by the time I read it,
Not to
I'll,
worry.
I'll
You can
text you.
tell me later. So I know that Sarah is a judge as well. I'm guessing that's just the three of us.
Yes. Hello. Hello, everyone.
Hi.
Pleasure to meet
Hello,
you.
fellow judges. Nice to meet you.
I don't know, Sarah, if you want to chair it. I know that I think we're supposed to say if we've seen either of the teams before. I've just been in around with an Amity team, although they were in a different position. I think I heard the appellant, and they're going to be the respondents in this round. So that's my declaration.
Thank you very much, Lee. No, I never met both of the teams so far, so I'm fresh.
Same over here. I have no conflicts whatsoever with any of the teams.
Obviously, all judges are open to bribes should the teams wish to do so, even at this late stage. I don't want to rule anything out.
Can we have the teams open up the cameras if possible? Nice to see you.
And congratulations, everyone, for getting to the semi-finals of this inaugural DIFC Digital Economy Court mooting competition. Very well done.
Thank you.
Thank you so much.
Congratulations to all the students, also for my side, from my field.
Hello, everyone. I think all three judges are present. So if everyone else from the teams have joined, then please proceed and open the session. We have Sarah, Lee, and Srikant as the three judges. Good luck, everyone.
Thank you, Delvin.
Can we just check? We've got all four speakers here. We've got, who do we have from Hamad bin Khalifa University for the appellant?
I will be the Aisha Bashir. I'm Aisha Bashir, and I will be the senior appellant. And my co-counsel is Tasneem Hussain. She will be the junior appellant.
Thank you very much. And who do we have from Amity for the respondents?
I'll be the senior respondent, Faiza Farhana, and my co-counsel, Shweta Sabuchi, shall be the junior respondent here.
Okay. In that case, unless any of my fellow judges have any questions, we'll ask the senior appellant to open the case.
Thank you, Your Honor. Good afternoon, Your Honors. My name is Aisha Bashir. I am the senior appellant representing Mr. Liat Payne. My co-counsel is Tasneem Hussain, the junior appellant for Mr. Liat Payne, and we are representing Mr. Payne against Ms. Rani on appeal from the DEC. Your Honors, this is a case about a party who freely engaged in capitalist speculation, a party who knew or ought to have known that letting a computer program commit her to an unlimited value of cryptocurrency purchase and having lost money as a result of her largesse, now wants to void the contract whose formation she delegated to an algorithm. This is a case about a party who carelessly enabled and now wants to walk away from her losses by claiming she was mistaken when she speculated on a notoriously risky commodity. A party who was sophisticated enough to design an algorithm to trade for her, but now claims that she was not alive to the chance that the trading platform circumstances could change, resulting in her loss, and that this is sufficient to set aside the contract she is bound to. The case is simple, Your Honors. Just as the contract law concepts of offer and acceptance are applied to algorithms, the common law concepts that courts do not intervene to save parties from a bad bargain, either through errors of judgment or carelessness, applies. And this is the case here, a simple case of a bad bargain brought about by an algorithm due to the respondent's carelessness in coding. Your Honors, we plead before the court that the trial judge erred in applying Al-Khurafi versus Bank Sarasin in concluding that the DIFC court had jurisdiction over claim by Ms. Razi against Mr. Payne under Article 5A1B of the Judicial Authority Law. I will be arguing this stance, and my co-counsel, Ms. Hussain, will be arguing that the trial judge erred in concluding that it was sufficient for the purpose of satisfying Article 37(1)(a) of the DIFC contract law that Ms. Razi showed that a reasonable trader with knowledge of the circumstances surrounding the transaction would have concluded that disputed trade was the result of an error. Your Honors, the dispute before us is about parties who were traders of cryptocurrency, which in this case was bought and sold on a platform called Clevity. The traders did not press buy and sell as you do on typical online selling platforms. Instead, the traders had set up programs to buy and sell for them using algorithms so that the purchase and sales would happen with no further human involvement. Ms. Razi had a program called Alpha, which bought Yapo, a cryptocurrency, at the best available price. She had programmed it to do so. And Mr. Payne had a program called Beta, which sold cryptocurrency based on the average price on the platform, unless no one else is selling, and then to sell for a higher price. On 10th June 2020, a problem occurred when for 20 minutes or 30 minutes, the platform mistakenly excluded all traders except for Ms. Razi and Mr. Payne. And as a result, Ms. Razi's program bought the only Yapo available, which was Mr. Payne's program, at 250 times the prevailing market price. These are the disputed trades, and both parties were asleep when this happened. Firstly, regarding the jurisdiction, Your Honor, I argue that the DIFC does not have jurisdiction over this case. In the application of Al-Khurafi versus Bank Sarasin, the trial court had seen that it does have jurisdiction. However, we argue that this is not the case. In Al-Khurafi versus Bank Sarasin, it was established that a branch was a separate entity, was not a separate entity, but an extension of a legal entity, giving jurisdiction to the DIFC as part of that extension, under the assumption that the entity will be sued or will sue from the place of jurisdiction. In that case, Your Honors, the contract was accepted within the DIFC branch. It had been done through the DIFC branch. Communications for investments were sent through that, instructions were sent through that, and telephones, emails, and fax were sent through that. The contract was therefore wholly or partly completed within the DIFC. And for the DIFC, as we understand, under Article 5A1B, for a civil or commercial claim or action to arise or be related to a contract or promise to a contract, partly or wholly it has to be finalized or performed within the DIFC or pursuant to some express or implied terms stipulated in the contract within the DIFC. For instance, when a particular commercial activity is carried on in the DIFC, which furthers or results in an incident that then brings forth the claim. In our case, however, we argue that this principle shall not be applied because the entity did not have, and the entity in this case being Clevity, did not have a branch in the DIFC. Instead, they had nodes. And while nodes are known to be pivotal in blockchain, that they record and simultaneously have a lot of information structure involved in them, we must understand that they are at the same time equipment used, not akin to a branch, in that you would not expect to sue or be sued by the node itself, or you would not expect that this would be a pivotal point. Furthermore, Your Honor, there is nothing to evidence that the transaction or incident took place on this particular node. Nodes communicate simultaneously, but the transaction itself took place on the Clevity platform and was recorded using the ledger system throughout all the nodes. This would make it very difficult to then ascertain that this particular node had partly concluded the contract or caused a commercial activity as such to give the DIFC the entire jurisdiction in such a case. An essential element was not done through the DIFC or had commercial activities with the DIFC. In our case, there is nothing in the facts to suggest that this had occurred. Further, Your Honor, with regard to foreign non-convenes and our request to then have the jurisdiction be shifted to Oman, we argue that neither parties are members of the DIFC, thus, not to Oman, sorry, apologies, Your Honors, for foreign non-convenes, that the jurisdiction be that the place of business of Clevity. This is because neither parties are members of the DIFC, nor are they citizens, nor was there any transaction that occurred there. However, we do understand that when it comes to assets and losses in cryptocurrency, in the case of Tulip Trading Limited versus Bitcoin Associations for BSB, the court had us understand that the lex situs of the crypto assets should be where the control of the assets is resident. In that case, we had seen that the CEO of the company had lost control of their crypto account at their home in Surrey due to a hacking incident. And the company itself did not have any active business or bank accounts as such. And it was found that it should be the area of resident where the control was, that is their home office, in order to find the area where jurisdiction should apply. Similarly, it should be where the losses could be more felt. A company's management should be where its controls are located and where the parties are doing so. Neither parties were residing in the DIFC, neither party's trades took place in the DIFC, and Clevity did not have any form of business control within the DIFC or central management in the DIFC. It had a node which existed as infrastructure and did communications for tracking, but at the same time, there are hundreds of nodes all over the world. And in that case, we could argue that hundreds of jurisdictions all across the world could then bring forth their claims over the jurisdiction, which would bring forth what would paramount as chaos before us, Your Honor. And lastly, to further emphasize that they were not citizens, we also bring forth Mansfield, Coe, and Swan, a common law case within the federal courts of the United States. Although not binding on the DIFC, the DIFC has looked upon common law courts in the past for similar instances, and we do so in order to showcase that where the question of jurisdiction comes up, it is often that courts will state that it should be that jurisdiction should be refused if the case does not involve its own citizens or does not occur in its own territories. In Mansfield versus Swans, the claimants had two offices in Ohio and Michigan, and filed an action in Ohio State Court seeking to recover damages against the defendant's railroad company and another entity for alleged breaches of a contract regarding construction of a railroad. Claiming the partners were not citizens of Ohio, the railroad company requested the case be transferred from state court to federal court in its ruling. The court found that the Federal Circuit Court lacked jurisdiction in the case because the railroad company was not entitled to removal, because the railroad company's pleadings did not affirmatively state the citizenship of one of the partners. According to the removal petition, that the partner and railroad company were citizens of the same state at the time the action was first brought in the state court, It did not affirmatively appear that he was a citizen of any other state at the time of the removal. Similarly, in our case, Mr. Liat Payne and Ms. Razrani are both not members of the DIFC, nor do they reside in the DIFC. Hence, the DIFC jurisdiction should not apply. And as we have stated before, the nodes were, only one node was present within the DIFC. The platform of Cleverty uses a distributed ledger across the network hosted on hundreds of nodes in many different countries across the world. And a node is a component required by cryptocurrency, but it does not mean that it gives it a full jurisdictional power in the sense that it does not give citizenship or constitute a branch. We plead before your honors to hold a decision in the Court of Appeal and overrule the decision made in the Court of First Instance. Thank you, Your Honor.
Can I ask you, if we have a look at Article 5, we've got the phrases whether partly or wholly concluded. So if a contract can be partly concluded, finalized or performed in the DIFC, presumably it doesn't matter whether there is one node of hundreds in the DIFC or indeed 99 out of 100. Isn't that just sufficient for us to get through this jurisdiction gateway? Because at the end of the day, what's the harm? We're a specialist digital economy court. We're very well equipped with specialist judges, not me, but my co-judges are very, very good at this sort of thing. We could try the case today. What's the problem?
With regard to that, Your Honor, it would then bring up the issue of opening up avenues all across the world and setting a precedent for that, as well as the fact that it is difficult to ascertain even a partly portion as in nodes as well. It is not just that they simultaneously work in that. Often the nodes will then in distributed ledgers simultaneously be working as a means of recreating or making sure the data is consistent throughout. But this does not suggest that it would then also be partly concluding on that. Indeed,
well, they verify and record, don't they? So presumably one could say that verification is the final step before the contract is concluded. And we understand what you say about, well, there's lots of nodes in lots of different countries, and that theoretically you could argue for jurisdiction in any of them. But isn't that a reason for us to say, well, sure, but we're seized of it now. We do have a connection. The claimant could have chosen to issue in a different jurisdiction, but she's chosen to issue here, and we get through our gateway, don't we?
It would, to an extent, work as such. However, that would then, as we've said, open up avenues to have a lot more. And while this is a specialized court, which does deal with digital economy, it does then bring up the issue of there could be other specialized courts in other areas that would then have conflicting jurisdictions on the matter, which could then give rise to that. And following the idea of having it go where the platform itself is located then gives us a more concrete idea, similar to how we saw in Tulip, that we have a fixed area of this is where the control is, rather than this is where each of the branches. And it also makes it easier to then reach those parties.
Can I perhaps follow on with the co-judge's question? And if you say that it could open a floodgate of jurisdiction, so what would be, in your opinion, be the right jurisdiction for this? One, and the follow-on to that question would be, would we take into account, if you say that the jurisdiction is Oman, should we take into account the recent warning that is issued to the Oman government, which says, beware of cryptocurrencies, and that could be a cause for us to perhaps ascertain that we have a jurisdiction?
I would like to apologize. It was a slip of tongue when I said Oman. I meant to say where Cleverty is based instead. I have tried to correct myself initially. What we believe is that it would make more concrete sense to follow where the platform is based, as it gives all parties an idea. And because the parties are contracting through the platform rather than through the nodes, so they are not consciously aware of the nodes themselves. You would not be aware of particular nodes that you are doing business through, but you are aware of the platform you are doing business through, and that would give all parties a conscious idea, at least, of what is happening. And further, we believe that wherever Clevity is based is a better suited platform, because that is where the company is, and parties can bring in their disputes through that avenue.
Sorry, for all we know, Clevity could be based offshore in somewhere like the Maldives, for all we know. Why would that be a better jurisdiction? Clevity is not even a party to the contract, is it? Why would that be a better jurisdiction than here? We don't know where Clevity is based, actually, do we?
We do not know where Clevity is based. However, the jurisdiction in that sense would be best suited, because that is where the control of the assets or the crypto is. As we understand, a lot of the time crypto is kept in certain wallets or such that is based in that company itself. So it is easier to reach into those pockets or those areas through that.
You said earlier that jurisdiction should also, or I don't know if you said it should be solely determined by or just taken into account, but you used the phrase where the loss is felt. Well, the claimant is in Dubai. Presumably it was felt in her bank account. For all we know, her Dubai bank could have its headquarters in the DIFC. If that were the case, would you then say that the DIFC would be the right place to try the case?
The losses would still be felt through the platform, we believe. So because the changes are done through the platform, are kept on the algorithm. So we feel that it would be, the platform would be best suited. But then if Ms. Rani would be open to the idea, we could look into that.
Because at the moment, if I could follow on that, at the moment, without a concrete base for where to try this particular matter, shouldn't we have, do we have an obligation under international law to actually, since we are seized with this particular matter, shouldn't we decide on it? Would we have the jurisdiction naturally, because of the fact that we are not able to establish jurisdiction as to where it is?
Apologies, Your Honor, I could not hear you after private of international law.
So, since it's a question of the matter that we're seized with, shouldn't we have a jurisdiction naturally? Does the IFC rule prohibit, or is there any jurisprudence / any authoritative material that you're relying on, which excludes us in jurisdiction as a matter of fact?
The authorities we are relying on to exclude is Sarasin itself, in the instance that they talk of how a particular commercial activity carried in the DIFC furthers or results in the incident or transaction, whereas we argue that there has been no commercial activity as to the matter that would further the incident itself within the DIFC.
Can we just understand what you're asking us to do here? Sorry, I do apologise if there's background noise where I am. I don't know if it's coming through to you. I can hear it. I do apologise for that. We just want to understand, the submission you've made to us is that jurisdiction should be wherever Clevity is based. But you've also told us that Clevity has nodes all over the place and we don't actually know where it's based. So if we were to deny jurisdiction, you couldn't even tell us where this case should be tried. So isn't that a good reason for us to simply, as my brother judge said, since we're seized of it, if you can't tell us where a better jurisdiction would be precisely, you're just saying, well, it might not be here, we don't know. Isn't that a reason for us to just keep the case here?
It could be argued that that would be that process, but we do not know where Clevity is based on the facts, but Clevity is a platform that is registered and operational in the world. So it would, as you had also said, could be registered in Maldives, and that would still be a platform or an area we can take the case to. As for the hundreds of nodes, we argue that we should not consider any of the nodes as being a extension of Clevity for the purposes of jurisdiction.
All right, well, thank you. I'm conscious you'd said that you'd finished your submissions. I think you'd said. I was just going to check if Sarah, who's our third judge, had any questions for you. And if she didn't, then we'll move on to the next speaker. But I just want to check, Sarah, if you had any questions, because you've not asked any.
Yes. Thank you, Lee. Thank you. Actually, my question. Oh, sorry, I am without video. Sorry. Yes, actually, my question would be exactly the same. If not DIFC, which jurisdiction could be? I don't know if we may maybe try to not to think just about Clevity and to think about the physical people involved for figuring out an alternative jurisdiction that this could be good to propose to the judge, and especially if there is some jurisprudence, some judgment that you will find in order to figure out an alternative jurisdiction. So, yeah, that would be my question as well. Thank you.
Well, if Clevity was not an option entirely and we had to pick another jurisdiction, then I believe that the nationalities of the parties would be in play here, and we could then look into the nationalities of the parties and go based on that. If we are not looking at the business, then at least where the operations occurred and such.
Thank you. And did you find some jurisprudence that can sustain your thesis during your researches? If so,
unfortunately, I do not have one right now, Your Honor.
Thank you very much. No more question from my side. Thank you.
Well, in that case, thank you very much for your submissions. If we could move on now to the senior respondent, please.
Am I audible? May it please the court, your lordships. I'm Faiza Farhana, and I appear on behalf of the respondents in this instant case with my learned junior, Shweta Sabuchi. Your lordships, I'll be addressing the first ground of appeal. That is, this court of first instance did not err in concluding that it has jurisdiction under Article 5A1B, and my learned junior will be addressing the second ground of appeal, that the court did not err in concluding that for the purpose of satisfying Article 37(1)A, that a reasonable trader with the knowledge of the circumstances could have concluded that the disputed trade was the result of an error. Your lordships, in relation to my first ground of appeal, I have two submissions to make. Firstly, is that the node in the geographical territory of DIFC allowed for Ms. Rani to perform or conclude the contract. Your lordships, the gateways under Article 5 of the Judicial Authority Law number 12 of 2004, which can be found on page 31 of the court bundle, clearly set out the gateways. Your lordships, what's peculiar about these gateways for jurisdiction is that they do not relate to the location of the parties nor nationality of the parties. What matters is the subject matter of the jurisdiction. And specifically in regards to Article 5A1B, if a contract is either partly or wholly performed, concluded, or finalized within DIFC, that would be sufficient to meet the gateway under Article 5A1B. Your lordship, for this, I would like to rely on the case of Corinth Piper SA versus Berkeley's PLC, 2011 DIFC Court of Appeal 002, which can be found in paragraph 21 of the case, your lordship. Furthermore, in relation to this case, in the case of Shihab Khalil versus Showa Capital, 2009 Court of First Instance, the court had interpreted the meaning of the word conclude to be as even as partially entered into, your lordship. So even if a party has entered into, have partly agreed, that would amount to meeting the gateway. Your lordships, for reference, you may turn to page number 52, paragraph 18, which states the following. Your lordship, now in context of the present case at hand, Mr. Payne had made an offer through his algorithm beta, to which Ms. Razi had accepted through her algorithm alpha. Now, for Ms. Razi to enter into this very contract, it could not have been possible without the node in the IFC lordship. That is because nodes in a distributed ledger technology, they act as mediums of communication. So not only do they allow the users to interact in the market, let alone they allow them to enter into contracts. Your lordships, for this, I would like to cite white paper on distributed ledger technology, which was published by the government of the Hong Kong Special Administrative Region of the People's Republic of China, cited in page number 81 of the code bundle, your lordship. Furthermore, so Razi had only entered into this contract because of the node in DIFC. In that regard, your lordship, nodes in a distributed ledger technology, they execute contracts when certain predetermined conditions are met. For instance, in this case, when the predetermined condition of the best possible price and the average price, it triggered the nodes to execute the contract, your lordship. Your lordships, for this, I would like to place my reliance on the research and analysis of blockchain data, which was published by the Journal of Physics and the conference series, which is cited on page 81 of the code bundle, your lordship. In that regard, it was at least partly concluded in DIFC, lordship. Furthermore, as I stated earlier, the location of the parties or branches do not matter in establishing this very gateway, as they only relate to the subject matter of the contract with nexus to the geographical location. Lordship, moving on to the consensus mechanism. So once a contract is executed or it's carried out by a node, it is then broadcasted to the other nodes in the network, and they validate and verify. So that's how it is concluded, the entire contract. And that's how it is a distributed ledger technology's immutability aspect comes into play. Therefore, one cannot ignore the fact that the node in DIFC had allowed for the consensus mechanism. Your lordship, now the consensus mechanism is relevant to the present case because these are essential steps in partial conclusion or negotiation of the contract, your lordship. For this, I would like to cite the case of Al-Khurafi versus Bank Sarasin, 2011, DIFC Code of Appeal 003, which can be found on page 42 of the code bundle, your lordship. And paragraph 59 of the case, of the very case, clearly states that the Dubai branch, though it was not involved between the allegations between the plaintiff and the Switzerland branch, it performed essential functions or actions to fulfill that contract. For instance, they had sent communication, they had sent receipts of the contract, they had signed off the contracts. So all this amounted to essential activities and negotiation of a contract, your lordship. In that regard, this would be sufficient to meet the gateway of Article 5A1B as well, your lordship. Furthermore, paragraph 16. Yes, your lordship.
I was going to ask, if we just look at Article 5, and we've got the phrases here, concluded, finalized, or performed. Now, I assume that concluded means where it's made, and finalized, I suspect, is probably similar. I think we've read in the other case that the difficulty is this article was originally written in Arabic, and so there was a translation issue. But presumably, in terms of whether we're looking at where it was negotiated or where it was concluded, what we've got, it seems to me, is one person in Dubai on their computer and one person in Oman on their computer. It doesn't matter where the information passes through. At the end of the day, there's an offer being made by one and accepted by the other, and one's in Oman and one's in Dubai. Isn't that, the nodes have nothing to do with the conclusion of the contract, do they? Or the finalization?
Your lordship,
is that,
well, okay, sorry.
And then, so that was my first question. Isn't it really that the contract was negotiated and concluded by these two people's computers in their respective homes or offices, wherever they are? And then if we look at performance, we look at Article 5, and it says, concluded, finalized, or performed within DIFC, or will be performed, or is supposed to be performed within DIFC. But then we have these words, pursuant to express or implied terms stipulated in the contract. So surely this is only a relevant gateway on performance. if it's an implied or expressed term in the contract, that it should be performed in the, and unless I'm missing something here, isn't it that there's a whole network of nodes all over the world? Nobody was particularly bothered whether there was one in the DIFC or not. Can you help us on that? Those 2 points?
Yes, Your Lordship. Your Lordship, as I stated earlier, the meaning of the word conclude would mean entered into. This was interpreted by the DIFC courts in the case of Shihab Khalil and Showa Capital. Even then, if the word conclude wouldn't mean entered into, when we look at paragraph 60 of the Al-Khurafi case, even when a contract is partially agreed upon, would be enough to substantiate it met the gateway of Article 5A1B. Moreover,
but if it was being negotiated and then entered into by the parties, and we know they were using computers whilst they were, it doesn't matter, but one of the parties is doing it through their computer in Oman, the other party is doing it through their computer in Dubai, but neither of them are in the DIFC.
Okay. Your Lordship, the facts of the case are silent in regards to presence of a node in Oman. Secondly, the location of the parties is required to maintain jurisdiction on these gateways. And thirdly, Your Lordship, even if it's partially agreed upon, it would be sufficient to meet the gateway, which is mentioned in paragraph 60 of Al-Khurafi. So even the fact...
But sorry, the reason we're asking you is because you're telling us that the contract was concluded or entered into in DIFC because there's one node. And what I'm suggesting to you is that it's not the node where the node is, but the node isn't entering into the contract. It's the parties that enter into the contract. The function of the node, as we understand it, is that it verifies the contract after it's been entered into, and it records it after it's been entered into. But the act of negotiating the contract and entering into it happens in the respective by the respective parties, not the blockchain technology.
Your Lordship, in regards to that, the node is actually hosted on a server in DIFC that's operated by Cleverty. So the server is a physical aspect of that very node. Secondly, even if Ms. Razi is domiciled in offshore Dubai, it would still require her to go to the server because it is a physical manifestation. That is a hardware aspect of the DLT. Your Lordship, I would like to place reliance in the ITUT technical report, which was published in 2019. It's cited in page 81 of the code bundle, Your Lordship. Your Lordship, would that suffice? Also, another point, Your Lordship. Any essential activity in furtherance of a contract in DIFC would be sufficient to meet the gateway, Your Lordship. This was also mentioned in paragraph 60 of the same very case. So the fact that all the nodes, whether regard one node or every node, we cannot ignore the fact that these nodes, they execute the contract. They are the main reason why these contracts are being performed. In absence of these nodes, one cannot contract with each other on a platform such as a Cleverty. Therefore, even the presence of one node in DIFC which have involved would be sufficient. Your Lordship, also the jurisdiction of Article 5A1B is very expansive. And this expansive nature of jurisdiction was analyzed by courts in several cases. Just to name a few, in the case of Gavin versus Gaynor, Lordship, if you allow me a minute. Gavin versus Gaynor, DIFC Code of First Instance 017. Your Lordship, in this case, only because a letter was addressing a meeting in DIFC that was sufficient to hold that the gateway article of 5A1B was met. So in that regard, it's really immaterial to determining jurisdiction whether there are multiple nodes across the network or not. As long as there is a single node in DIFC that is performing function in regards to conclusion, performance, or any relevant activity in regards to the contract would be sufficient, Your Lordship. Lordships, if that suffices, may I proceed with my submissions? Your Lordship, this aspect of identifying where this transaction takes place, our nodes even determinative in jurisdiction, was addressed in several cases, especially in a US case by the name of Ray Tezo's civil securities litigation in the US District Court for the 9th Circuit in the year 2018, which can be found in page number 50 of the code bundle, Your Lordship. So in this case, it's a very similar case. It was between a US plaintiff and also Ray Tezo's, which was legal side was in the UK. However, I would like to contest the learned friends for the opponents by stating that it didn't matter the location of the foundation or the company because the transaction took place in the US. And they had arrived at the conclusion because much of the validating nodes were in the US, and these nodes were hosted, the website was hosted in Arizona, Your Lordship. So we can draw a parallel to the present case at hand. Firstly, these nodes did validate or verify the transaction. And secondly, it is hosted on a server, which is a physical aspect in DIFC, Your Lordship. Furthermore, Your Lordship, this integrity of service being determined.
Forgive me, if we look at the Tezos case, and it's, I think, page 52 of your bundle, the yellow highlighted, the bit you've highlighted in yellow for us,
yes, Your
it
Lordship.
says this: finally, his contribution of Ethereum to the ICO became irrevocable only after it was validated by a network of global nodes clustered more densely in the United States than in any other country. While no single one of these factors is dispositive to the analysis, together they support an inference that Anvari's alleged securities purchase occurred inside. So what they're saying there surely is that, yes, there's a global network of nodes, but they're clustered most densely in the USA. We don't have that evidence here, do we?
Yes, Your Lordship, I agree with that. However, here I would like to distinguish the gateways between the US and the DIFC, Your Lordship. DIFC doesn't require several activities. So the only similarity that I would like to link to the present case at hand is, since the jurisdiction of DIFC is very vast under Article 5A1B, even the presence of that one node which is performing an activity in regards to the contract would be sufficient, Your Lordship. This case is only to pertain to the fact that nodes are not irrelevant to determining jurisdiction, and that they're taken into considerations in international cases as well, Your Lordship.
Okay, thank you.
Okay. Your Lordships, I would also like to take this opportunity to distinguish a case that my learned counsel for the opponents have mentioned. That is the case of Ion Science Limited versus Persons Unknown. Your Lordship, a learned friend had mentioned the rule of lex situs. The rule of lex situs is not relevant in this case because it's a governing law principle. And also the circumstances in which they were applied in that specific case was because there was an aspect of fraud, and governing law was essential to determining jurisdiction under the UK civil law, Your Lordship, that is Practitioners Directorate 6B. Yes, Your Lordship. Furthermore, the way this case is different from the present case at hand, it is a fraud case. So in this case, the Bitcoins or the cryptocurrency was taken away from its rightful owner. So in order to establish it's a property claim, that is, the property must be retained back to its original owner, was why the location of the party was important, Your Lordship. The present case in hand has nothing to do with the property or the title, but rather a relevant mistake, which is a contractual dispute at hand, Your Lordship. Your Lordship, that suffices my contest. Moving on with my submissions, Your Lordship, there is also a lack of opt-out clause had they not wish to exercise the jurisdiction. However, there is a case law, but I will just move on with my second submission, Your Lordship. The principle of forum non-convenience is not applicable in this instant case. Your Lordship, this principle is a discretionary power of a court which already has a right jurisdiction to transfer the matter to another jurisdiction which is more appropriate. And this burden lays on the defendant, which would be the appellants in this case, to prove that there is this forum which they have failed to do so. This principle is recognized in the DIFC codes, most fundamentally in the case of Protivity Member Firm Limited versus Al-Mohel 2016, DIFC Code of Appeal 003, paragraph 48, no, apologies, page 48, paragraph 22, Your Lordship. And they have not established there exists a more appropriate forum, as the learned friend for the appellants have not yielded to the Oman's jurisdiction. I will not be contesting further, but still I would like to state that Oman is not even an appropriate forum for the fact that they do not allow for the protection of the traders who engage in cryptocurrency. And this was reiterated in October 11, 2022. So as of now, the Central Bank of Oman has even cautioned its own citizens, Your Lordship. Moreover, DIFC is an international, it litigates in English, and the documents are construed in English. So it's much more convenient for the parties.
So if I may, since you mentioned Oman, which was the exact point which I raised with your counsel, Oman has not banned cryptocurrency. So so there is a warning, but there's no ban, so to speak. So wouldn't that be the jurisdiction, if we may? I mean, your opposing counsel, of course, did mention and did take up that particular burden of proving to us that no other jurisdiction exists. So perhaps hasn't she satisfied the burden, so to speak?
No, Your Lordship. Well, I see where you're coming from, Your Lordship. However, the principle of forum non-convenience, the burden is on the defendant to prove there is a more appropriate forum. So the burden is on them to prove, in accordance with the convenience factor, there is another jurisdiction in terms of law, governing law, location of the parties, language of the parties, and other legal and practical issues that is more convenient, which they have failed to do so, Your Lordship. Even though cryptocurrency is not illegal, as of now, they do not have a law or a regulatory framework in place, Your Lordship, nor do they have a specialized code, unlike the DIFC codes, Your Lordship. Specifically, the DEC rules, which are on page 26, which allows for the Digital Economy Code to litigate on matters that are in relation to digital environment and cryptocurrency and distributed ledger technology, Your Lordship. So in that regard, the DIFC code does have jurisdiction and more appropriate, if I may be honest, and which they have not disproved to be dishonest. And Your Lordship, that concludes my submissions for the first round of appeal. It was a pleasure arguing in this court. If I may be of no further assistance, I will now refer this court to my learned friend for the appellants, Your Lordship. Much obliged.
Can I just say, just so that everyone's aware, one thing lawyers should never say, certainly in court and even to a client, is if I could be honest. The assumption is lawyers are always honest. What we occasionally have to be is frank. Never say if I could be honest. I'm teasing you, but it's true. It's a style point. It's a style point. Lawyers are always honest, but occasionally have to be very frank. Anyway, on that amusing note, if we could ask to hear, please, from the Junior Appellants Counsel.
Hi, good afternoon, Your Honors. My name is Tasneem Hussain. I am the junior appellant representing Mr. Leith Payne. I'll be dealing with the second issue. And the issue is whether the first instance court erred in concluding that for the purpose of the claim to avoid the disputed trade, it was sufficient for the purpose of satisfying Article 37(1)(a) of the DIFC contract law that Ms. Rani showed that a reasonable trader with knowledge of the circumstances surrounding the transaction would have concluded the dispute trade as a result of an error. What I will be arguing today, and it's based on Article 37(1) and 2 of the DIFC Law 6 of 2004, is that there was no mistake at common law or in equity. First, I think getting straight into it, in Article 37 on relevant mistake, Article 37(1) says a party may only avoid a contract for mistake if, when the contract was concluded, the mistake was of such importance that a reasonable person in the same situation as the party would have concluded that it was the true state of affairs. And it requires that they know or ought to have known of the mistake. So if we analyze this, in a unilateral mistake, one party that has transacted has to have been operating under a mistake as to the fundamental contract. And in this instance, you have to take into consideration the state of the mind of the parties. And this is where I'm going to be focusing. If we look at the doctrine of unilateral mistake, either a common law or in equity, the former requires proof that the non-mistaken party had actual knowledge of the mistake at the time of the contract, and the latter requires constructive knowledge coupled with unconscionability, and I'm going to get into both of them. But just briefly before that, I just want to clarify that when we analyze this new paradigm that we have now of algorithmic contracts that are being formed, we agree with the learned judges in saying that in this instance, if we look at the formation of the contract took place when an offer was made by one algorithm and accepted by another algorithm, and the parties had agreed to contract using such deterministic algorithms. This is also found in paragraph 97 of the Coin case that was also used as persuasive and quoted by the court of first instance. This is important because the first thing we wanted to do was we wanted to show that the contracts existed and were binding, and that our client relied on that, which is also part of Article 37(1)(b), is that we had relied on this contract. But going back into 37(1)(a), if we look at unilateral mistake, when we look at how the non-mistaken party must have had actual knowledge of the mistaken party's mistake, If we try and analyze this, we also go back to coin and we look at two things that the court held. The court held that independent of and without knowledge of a mistake, there's no basis for one to rely on unilateral mistake at common law to avoid contracts. And in this case—
Ms. Hussain, can we ask you this? It seems to us, and I'm sure we can agree, what's happened here is that your client is a clever man and he's outsmarted poor Miss Rani. And you're saying he should be allowed to keep his profits. And she's saying, no, 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 that's not fair. He should give them back. That's what's going on here, isn't it? Now, your client programmed the algorithm to inflate the market price by 250 times. Wasn't that command lines wasn't that part of his algorithm, those instructions he gave his computer? Weren't they designed specifically to exploit some kind of error? Isn't that what they were for?
This is an excellent question. And this question, so we would argue that was not the intention of our client, Mr. Payne. And this is actually perfectly in sync with exactly what the court said, because the Court of Appeal held that the relevant, when you're trying to assess the information that they knew, or that Mr. Payne knew or ought to have known, the Court of Appeal said that they have to analyze, in this instance, because it's a deterministic algorithm, when programming the algorithm, whether the programmer was acting or doing so with actual constructive knowledge of the fact that the relevant offer would only ever be accepted by a party operating under such a mistake.
Yes, well, that's what I'm asking you. Sorry,
yes,
that's exactly what I'm getting into. Okay.
Yeah, that's exactly this is exactly what I'm getting into, because we're contending that this was not when Mr. Payne was programming this event, was programming his algorithm, he was not programming that it would only be operating under a mistake, and rather we contend that this is a genuine transaction. I think the first thing that we want to say is that he said the way in which the algorithm was created was not created into putting the price up to 250 specifically, it was inflating the price. And what we would like to say is that this is an actual scenario that can happen in a cryptocurrency world when you have demand and supply that are dictating the market. When you are in a market, especially once as volatile as cryptocurrency, when you have a very high demand and very low supply, the market prices are going to rise. And that's the way in which he had programmed the algorithm. So in this instance, I think that they're the ones who are going to have to show us that the intent was specifically to characterize or to take advantage of someone's mistakes, where we believe that this is not something that was that could only have come out of a mistake. We believe that in cryptocurrency, people buy to sell.
In London, this is what we call price gouging, right? That's the word that's used, gouging, as if you're poking someone, because what you're doing is you're deliberately inflating it to a really high degree. And what I'm asking you is, if he's deliberately programming it to say, what he's effectively saying is, under certain situations, raise the price by 250 times the most recent market value, and presumably thought to himself, well, let's just see if there are people who are not as clever as me, haven't thought about this sort of loophole, and haven't thought to program their computers to stop them falling into it. I mean, isn't that what's happened here? Presumably, if these people were dealing together as humans, and I understand what you would say, well, look, he's programmed his computer to sell at the best price, she's bought it to buy at the best price, and all that's happened here is there's just one buyer and seller, and both programs are performing as they ought to. And we understand you're going to say that, but if poor Miss Rani was there at the time, wouldn't she have said, well, hang on, I didn't mean in this situation? I think that's what she'd say, isn't it? There's
two things that we want to say here. I think the first thing here is that we must draw a distinction between the specific market that we're discussing right now and how a reasonable trader in this specific market could have foreseen such developments. And I think, again, if I would just point to the crypto market specifically, because to us, when we're analyzing a price increase of 250%, which isn't what he set it at, he only set it to increase. The only reason why it went up to 250% is because there was such high demand and he was the only supplier in the market, which is the first thing that we think. And we think that in that instance, that it was up to Ms. Rani, given that she was entering such a bullish market where buyers are optimistic about price rise, prices and where buyers buy at higher prices to sell at even higher prices. That's the nature of cryptocurrency. In that instance, we feel that her algorithm is the one that perhaps should have kept spending. We believe that cryptocurrency is highly volatile asset, subject to unpredictable fluctuation in price.
But that's what we're saying to you. We agree with you that if she was as clever as your client, she'd have put in a capping mechanism. And what's happened here is that your client's so clever, he's thought, well, I'm gonna program my computer and hope that no one else is as clever as me, and that's all that's happened, isn't it?
But I think in this instance, it's not the court's place to decide who is a clever trader and who is not a clever trader. And it's not the court's place to decide who is a victim because of a bargain or a bad deal that they happen to get themselves into. This is also very common practice in common law, is that the courts are very weary of interfering in bad contracts or bad deals. We see often that individuals get themselves into such situations if they are not as clever as our client. But however, that doesn't necessarily mean that the contract was not valid and that our client had ill intentions. Our client did not have ill intentions. These are basic market principles of supply and demand and basic market principles of price increasing when there is a higher demand, especially, and this is what we want to say in the cryptocurrency world. We think that it's a reasonable trader in cryptocurrency would foresee such market developments to occur, especially given the nature of the program Ms. Razi made. We want to discuss here, and I think this is all building up to the second thing that we were discussing, because if we go back to the law, if you look at Article 37.2, a party may not avoid a contract if Article 7.2b says the mistake relates to a matter in regards to which the risk was assumed. So the question that we want to ask the court today is, was this really a mistake, or was this an assumed risk that Ms. Razi took upon herself when she decided to play the market, which is exactly what she did. She decided to play the cryptocurrency market. If she had hit it big, she would have been very happy. She did not hit it big because her algorithm was not sophisticated enough, and therefore she's a little bit upset. If we analyze in Coin, for example, the case that was also referred to in the court of first instance, the Coin's trading software algorithm had 12 different algorithmic trading strategies to create a strategy chain. This is how sophisticated the nature of the market is and how sophisticated you have to be as a player in this specific market if you want to survive and if you want to hit big and be an overnight multimillionaire like people are in the cryptocurrency world. And this is why we're saying that under that's why we're saying that in this instances, cryptocurrency exchanges do not raise alarms. You as an individual, this is done automatically through algorithms that are run by professional traders. You have to be highly vigilant, and you have to be very careful in the way in which you are able to create your algorithm. That's why we believe that in this instance, if you look at Article 37.2, we don't think that this is a mistake, and we don't think that she can avoid the contract, because this is a risk that was assumed, and this is a risk that she should have known. She should have had layers in her algorithm. She should have kept the amount of spending in her algorithm. Furthermore, we also want to include that in this instance, her algorithm, even if we take out my client from the equation, even if we take out the glitch from Clevity from the equation, her algorithm would have done the exact same thing. If you put her algorithm in any other sphere and there was one buyer or even two buyers, her algorithm still would have bought at a higher price, because her algorithm was not taking into consideration monopolistic tendencies in the cryptocurrency world, which is why we're trying to say here that even devoid, we think that they can't prove ill intent on the part of our client, who is just trying to do business in the cryptocurrency world. But even devoid of that, we think that her algorithm would have made a similar mistake. I think the second thing that we want to look at is we want to look at mistakes in equity, because we feel that if this is a case, if there is a case for her, the case for her is if we find a mistake in equity. But even here, if you look at mistakes in equity, they must have been engaged in some unconscionable conduct in relation to that mistake, which is what we've been discussing just now. And very importantly, if we look at page 22, paragraph 43 of the Coin case, the judge held in that instance that conduct, even if opportunistic, was not sinister. And this is the judge trying to say that this is how the market works. And even if I'm trying to make profit, and even if I'm trying to be opportunistic, which isn't what we're trying to say, because we're trying to say that in our instance, we genuinely believe that it could have been that our client thought that someone was buying in order to sell later. And it could have genuinely been that there were no sellers in the market because people were hoarding, because that's what people tend to do in a cryptocurrency, which means there are instances where there could be only one seller within the market. We say that you're not able to show that there is any sort of sinister intentions behind what Mr. Payne was doing, besides being very smart and having a really good algorithm in that instance. Yes, sir.
So he's a good man, albeit a very ruthless man. That's what we should find, is it?
Yes, but I feel as though courts should not punish ruthless businessmen. Ruthless businessmen. In this instance, that is all that is really all that it is. I mean, we're in Qatar right now, and we're paying a fortune for housing because of the World Cup. But that's just how it works. That's inflation. When there's a high demand and there's very little supply, this is eventually what's going to happen, and that's how things work. And that's why here we believe in this instance that if you look at the law, if you look at Article 37.1, you cannot say that in this instance that he was aware or that he knew for sure that this was only going to be, that when he was programming this algorithm, that he was only going to be sort of taking advantage of a mistake. So we cannot say that there was any knowledge. If we look at Article 37.1b, there was reliance because he knew that this was a contract, and he relied on the validity of this contract. If you look at Article 37.2, we say in this instance that a party may not avoid the contract if the mistake is an assumed risk and not necessarily a mistake. And we would say that even if, for example, and these are the laws within, but even if you want to look at the UNIDRA law, we feel that in UNIDRA it is almost identical. If you look at Article 3.2.2 2b, it says exactly the same thing. A party may not avoid a contract if the mistakes relate to a matter in which the risk of the mistake was assumed. And that is why in this instance, we don't believe that there was a mistake either in common law or in equity. Thank you very much.
One final question we have to ask. If you're being frank about this, like your previous counsel, why didn't you take the negligence point? Why not also say that you know, it's not just that she assumed the risk, but she programmed the algorithm. If she's got a problem with it, she's grossly negligent.
We have no problem with taking with taking that on. We were just following the issues based on the appeals, the issues that were handed to us based on the appeals court. But yes, if you are
it's paragraph 2A. You've relied on 2B. I'm just saying, you know, given your love of the ruthlessness, we're surprised and a little disappointed you didn't go under 2A as well to really gouge the.
We just really think that everyone is always afraid when there's a new market, and everyone is always trying to jump on the regulatory bandwagon, and regulations are important, but at the same time, trade is important. And at the same time, you cannot punish individuals who are good at what they do. And whereas we feel for Ms. Rani, I don't think that in this instance, a court should step in because of a bad decision or carelessness on her part when she was coding.
Thank you very much.
Thank you. Thank you.
If we could now move to the junior respondent.
May it please the Lordship, as already been indicated, my name is Shweta Sabji and I appear for the respondents in the second round of appeal. In relation to the second round of appeal, there are 3 submissions to be made. The first submission being the act done in good faith. It is humbly submitted before the Honorable Court that the contract was not in accordance to good faith. Good faith basically means the observance of reasonable commercial standards of fair dealing. If the contract lacks the concept of good faith, it will lead to imbalance and hence would be unfair. May I refer your Lordships to the case of CPC Group Limited versus Qatari Dyer Real Estate Investment Company, which is cited in page number 14 of the bundle, and this was held in England and Wales High Court 2010. It was stated that observing reasonable commercial standards of fair dealing, being faithful to the agreed common purpose, and acting consistently with the justified expectation is necessary so that a contract becomes enforceable. Your Lordships, in this instant case, as Spain has given the asset at a highly inflated price, to be more specific, 250 times more than the actual price, there is no observance of reasonable commercial standards of fair dealing. Moreover, Lordships, now I may refer your Lordships to the case of Yamsung PT Limited versus International Trade Corporation, which can be found on page number 69 of the bundle, and this was again held in England and Wales High Court 2013. The council would like to stress on the term that good faith is implied in nature.
Hence, it's an implied duty to act in good faith. Furthermore, I may refer your lordships to Article 1.7 of United Principles of International Commercial Contracts 2004, which can be found on page number 21 of the bundle. It states that the concept of good faith and fair dealings is fundamental and core to any contracts. And it also conveys that the parties has a duty to act in good faith and hence must not exclude or limit it. Hence, one can understand the importance of good faith in contracts. In addition, your lordships, I may refer your lordships to Article 56 of DIFC Contract Law number 6 of 2004, which states that good faith, fair dealings, and reasonableness is an implied obligation. Hence, good faith is a faithfulness to scope, purpose, and terms of the contract. To ensure that both the parties get the benefit from the anticipated benefits of the contract, both the parties need to act in good faith. As stated before, observing reasonable commercial standards of fair dealing, being faithful to the agreed common purpose, and acting consistently leads to good faith. May I refer lordships to the case of Braganza versus BP Shipping, which can be found on page number 56 of the bundle, and this was held in United Kingdom's Supreme Court in 2015. It stated that the duty must be rational, and rational basically means duty to act in good faith. I would again like your lordships to refer the case of Braganza versus BP Shipping, which can be found on page number 56 of the bundle. So Braganza duty requires a decision maker to exercise its discretion honestly and in good faith, and there must be an absence of arbitrariness, capriciousness, perversity, and irrationality. A so-called Braganza duty is an implied obligation to act rationally and must exercise the contractual discretion. The implied concept of good faith and fair dealings is a rule used in all the courts in the United States and requires every party in the contract to act in good faith. Moreover, your lordships, the rule applies automatically without being stated in the agreement. In accordance to laws. Yes, your lordship.
I'm so sorry to interrupt. Can we just ask you, obviously, we see what you're saying, both orally and your skeleton about duty of good faith. We don't disagree with that. What do you say to your opponent's point, which is that in effect, her client was acting in good faith. He's ruthless, but he acts in good faith and within the bounds of the law. What do you say to that?
So, your lordship, in accordance to good faith, it is to be reasonably acting in a reasonable manner. It is basically in accordance to acting in a reasonable manner. So reasonable manner basically means not charging at a highly inflated price. And hence, in looking onto the concept of reasonable person, a reasonable person would not enter into such a contract as it is inflated, and the concept of reasonableness will be addressed properly in my third submission.
So just so we understand, is it the reason you say it was unreasonable and not in good faith? Is that because it was a 250 times more than the market price?
Yes, your lordship, as it is unfair and
yeah. So if it was 10% more, would that be in good faith?
It depends upon the situation, as the clevity is operating under a mistake, your lordship. The clevity is operating under an error, your lordship.
So are you saying that when clevity has got an error, there should be no trades at all? Or is the problem that he inflated the price by so much? Because I think the difficulty that myself and the other judges would have is, where do we draw the line? If it programmed his computer to say, well, when there's no one else, add 10%, you might say, well, that's a fair profit. And we understand what you're saying is, well, it's so extreme, it's 250. But where do we draw this line? Can you help us with that? Or is that not the right approach at all for us to look at the numbers in that way?
Your lordship, as there was an error in clevity, and at that time, maybe there will be more other participants as well in the market. So hence, at that time, as it was inflated, that is 250 times inflated, there should not be any activities happening at that time, because it wouldn't lead to an unfair situation. Moreover, your lordship, the implied convent In accordance to the case of the Corin Investment Limited versus Leicester Properties Limited, which was stated that there were three principles to be applied. The first one, the obligation on the parties to cooperate and achieve the contractual obligation. The second point being the compliance of honest standards of conduct. And the third point being the compliance of honest standard of conduct in accordance to a reasonable person. Moreover, Your Lordships, in according to the Australian common laws, the development of good faith began to the recognition of development to cooperate. So development to cooperate basically means to act in good faith. And hence, good faith is given so much importance. And so, in the instant case, as there was no mention regarding the good faith due to the extraordinary pricing, by the appellant, there is no concept of good faith, Your Lordship. And moreover, Your Lordship, in this case, as you mentioned before, it is unfair because the inflated price is not due to the market condition, but due to the technical glitch on the clavity, which appellant made use of, Your Lordship. Your Lordship, in accordance to the second ground, which deals with proving mistake, may refer Your Lordship to the Article 37 of DIFC Contract Law number 6 of 2004, which can be found on page number 29 of the bundle. So in order to prove mistake under this article, one has to prove the non-existence of good faith and non-existence of reasonableness. And hence, in proving non-existence of good faith, Council has already proved in my before submission, and the non-existence of reasonableness will be proved in my further submissions. That's the third submission, Your Lordships. Moreover, mistakes has occurred in the instant case as one party is laboring under the misunderstanding as how the code will operate. May I refer Your Lordships to Hartog versus Colin and Shields, which can be found on page number 62 of the bundle. And this was mentioned in All England Law Reports, and this was held in 1939. The court referred to a principle called a snapper principle, which means when it is obvious that one party has entered into a contract by mistake and the other party snatches the offer and enforces it, this is not enforceable as it is unconscionable to do so. Moreover, there must be a secure sufficient protection for the consumers against unfair prices against these contracts. Hence, Ms. Rani, being a reasonably sound trader, was aware of the fact that she would have never gone forward with such a trade as it is highly inflated, Your Lordship. Moreover, Your Lordship, in contesting what the appellant has said before, the appellant has said in regards to the state of mind. It is clearly mentioned in paragraph number 10 of the bundle, paragraph number 10 of the facts of the sheet, page number 4 of the bundle. It is clearly stated that state of mind is not to be used in this case, Your Lordship. Moreover, in regards, the Learned Council has also talked about the fluctuation in price, Your Lordship. The Council agrees to... Yes,
sorry, just wanted to ask you, Hartog and Shields, as I understand it, the issue there was that the parties were trading in Argentinian hare skins, and there was a mistake because one party was talking about the price per skin, and the other party was talking about the price per pound of skins. Yes, so one was talking about individual skins, the other was talking about quantity in weight. So that was a mistake of as to the terms of the contract, but there was no mistake of the terms of the contract here. There was a price that was agreed between these two computers and their algorithms. There was no mistake about that, was there? So I'm not sure, how does Hartog help us, if it does?
Yeah, sorry, I jumped in. Yes. I will also ask a clarification regarding the state of mind that you mentioned. Do you think there are differences between the state of mind of this case and in our case? Thank you.
Your Lordship, in answering the first question, which is in regards to Hartog versus Colin and Shields, it was stated that the defendant suffered a loss of profit and claimed damages. So in that case, it was held that there was no contract between plaintiff and defendant, as the court there has a duty to correct the mistake that is known, even though the party didn't have intention to be opportunistic. Hence, I would like to refer the principle of snapper principle when this can be applied in our case, which basically states that if one party is obvious that one party has entered into contract by mistake. On the other hand, if the other party has enforced the contract on the basis of snapper principle, it is unconscionable to do so. The Council would like to refer the principle of snapper principle in the Harder versus Colin and Shields. And in answering to the second question, which is regarding the state of mind, Your Lordship, in paragraph number 10, it is specifically mentioned regarding the state of mind of the programmer when designing the program is not to be considered. Moreover, yes, Your Lordship, this is in regards to the state of mind, which I would like to contest, which is in regards to Appellant. Appellant has talked about the state of mind, but in this case, the state of mind is not to be considered in paragraph number 10. It is clearly mentioned, Your Lordship. Moreover, Your Lordships, the Council seeks permission to continue with the arguments.
Yes, okay. From my side, yes.
Much obliged. Moreover, Your Lordships, in contesting what the appellant has said, the appellant has not cited any relevant authorities or precedents. And moreover, their thoughts upon this case are not binding on this court. And moreover, Your Lordships, the Council has also talked about fluctuation in the market. The Council would like to talk about that as well. In regards to fluctuation of the money in the market, the Council agrees to the fact that there is fluctuation in the market, but the fluctuation in the market depends upon the demand and supply of the market. But due to the fact that there was an error in clarity, only Payne was considered to be the seller, and hence demand and supply cannot be evaluated in the market, Your Lordship. The fact that Payne was the only seller in the market due to the error and cannot conclude the demand and supply factor, Your Lordship. Moreover, Your Lordship.
Sorry, can we ask you this? We hope and assume that since this incident happened, that your client, Miss Rani, has updated her algorithm. Otherwise, she could lose another $250,000 tomorrow. So I think our question would be, she could have programmed her algorithm to take account of this sort of situation before this trade happened. And if we look at Article 37, and it's the same point that I asked your opponent about. Section 2A says, a party may not avoid the contract if it was grossly negligent in committing the mistake. Now, if Miss Rani had been selling this algorithm to other people, and they had ended up falling into the same trap laid by the ruthless Mr. Payne, and they also lost $250,000, couldn't they sue Miss Rani for negligence? And if they could, doesn't that mean that in this case, we shouldn't be allowing her to avoid the contract? Can you help us with that?
Yes, Your Lordship. In regarding to a reasonable steps which is taken by Miss Rani, to take reasonable steps, it must be foreseeable. The risk must be foreseeable. But in the instant case, the risk is not foreseeable, Lordship. To substantiate this point, the risk of technological factor is being assumed as it is a smart contract. But the fact that inflation of price cannot be assumed as one entered into contract for a mutual benefit. So if someone sees the risk of an highly inflated price, no one will even start a smart contract. Moreover, Your Lordship, the concept of reasonableness basically means which is acting rationally is implied in the contract as which expects all the parties to act in a reasonable manner and providing a price which is reasonable for a person to accept. And hence the inherent risk is, as the inherent risk is not foreseen, there is no negligence in part of Ms. Rani. Moreover, Your Lordships, a reasonable person would not think of such a risk as the concept of reasonableness is implied. And hence this contracting parties would think that the other party will act in good faith and reasonably as the principles are implied, Your Lordship. The Council seeks a permission to continue with the arguments. Much obliged. Your Lordships, the Council would like to move on to the third submission in proving the objective theory, Your Lordship, which means reasonableness. The objective theory of contract holds an agreement between the parties is legally binding in the opinion of a reasonable person who is not a party to a contract, And moreover, Your Lordship, the objective theory is a sound approach where it looks into the pragmatic reality instead of looking into the externalities, Your Lordship. Moreover, there are reasonable expectations on reasonable person at that point of time, Your Lordship. And moreover, the objective theory looks is a hallmark principle for freedom and contract of personal autonomy, Your Lordship. May I refer Your Lordship to the case of Smith versus Hughes, which can be found on page number 65 of the bundle, and this is mentioned in Law Reports of Queen's Bench Division on 1871. And it stated that Spencer stated the objective theory, which means these are the words which are interpreted by a reasonable person at that point of time. And this was Spencer extracts these dictum from Blackburn J, which is to be found on page number 76 of the bundle. Moreover, Your Lordship, the objective theory is characterized as a tool of the courts to evaluate the formation of a contract, and hence objective theory is often the initial analysis of the court, which helps to know if a contract is enforceable or valid. Moreover, Your Lordship, hence a reasonable person would only engage under a reasonable price. A reasonable person is one which approaches the situation with caution, with a sensible amount of caution. And on the other hand, a reasonable, yes, Your Lordship?
So you're telling us about the case of Smith and Hughes.
Yes, Your Lordship.
This was something that happened in 1871. And the
Yes,
man
Your
was shown a quantity of oats that he wanted to buy for his horse, and he bought them. And then he found that his horse didn't like that particular kind of oats. And what the court said was, well, Mr. Smith, the buyer, that's your mistake. And you have to keep the oats. You don't get your money back. So how does that case help your client? Isn't she in the similar situation there where she should be bound by her mistake?
Your Lordship, the council would like to take the principle from that case, that is a reasonable person. So the council would like to elaborate what that reasonable person means from that case, which means a reasonable person would expect what according to at that point of time, and hence the council would like to take the principle from that case, Your Lordship. The point of reasonability, Your Lordship. Moreover, Your Lordship, now I may refer Your Lordship to the case of Coin PT versus B2C2, which is held in the International Justice of Singapore Court of Appeal. And this was, I would like to refer the opinion of Lord Mans, and this is to be held in page number 56, paragraph number 28 of the bundle. And in accordance to the opinion of Lord Mans, Mr. Payne's state of, in accordance to this fact of this instant case, Mr. Payne's state of knowledge for the purpose of proving Article 37, Clause 1, Subclause A of DIFC contract law, the court did not need to examine the state of mind of the programmer, and as the designing of the program was sufficient that a reasonable trader at that point of time would enter. The Lordship, the Lord Mans has also commented that what was prescribed as reasonable in sense of conduct or decision to which no reasonable person having relevant discretion could have subscribed. Moreover, Lordship, if we remove the factor of AI algorithmic factor, we are left with two parties, the first Payne and Rani, where one party is offering an asset at a highly inflated price where a reasonable person would not enter into such a contract, Your Lordship. Moreover, as Raj Rani is considered to be a person of ordinary degree of prudence and care, foresight and intelligence, whose conduct or conclusion or expectations is in relation to a reasonable person. Due to this, Raj Rani would not have entered into such a contract, which is 250 times above the actual price, Your Lordship. Moreover, the reasonableness is also being used in the Australian contract law, which tackle people walking blindly into danger. Hence, Your Lordship, this case satisfies all the elements of 37 clause 1 subclause A of the DIC contract law number 6 of 2004, we can conclude that the disputed trade was a fact of a result of an error. The principles of justice, equity, and good conscience must be taken into deliberation. Moreover, Your Lordship, as the counsel for the appellant do not cite any relevant authorities, neither persuasive evidence to substantiate their arguments. Moreover, they have also talked about fluctuating the concept of fluctuation, which already I have talked on. And moreover, uh, they have also talked about a reasonable trader, which I have already again talked on. And they have also talked about the inherent risk. So inherent risk, as already said before, the risk of technological factor is assumed as it is a smart contract. But as the fact of inflation of price cannot be assumed as they enter into contract for a mutual benefit. So as if this risk is seen, no one would even enter into contract. And hence the concept of uh, providing a reasonable price to a reasonable person would be accepted, Your Lordship. Uh, Moreover, Your Lordship, therefore, to conclude, I submit the judge not err in concluding that the DIFC Court has jurisdiction over the claim under Article 5A1B of the Judicial Authority Law because Clevity operated distributed ledger with a node in DIFC. Moreover, the judge not err in proving Article 37, Clause 1, Subclause A of DIFC Contract Law Number 6 of 2004 because a reasonable trader with the knowledge of the circumstances would not have concluded the contract. It was a pleasure arguing in this court. May the counsel be of further assistance in this court.
Thank you very much. I think, if I'm not mistaken, we've up till now neglected to invite the rebuttals. I don't know if my fellow judges, do we want to hear the rebuttals? Yeah, I'm getting nods. All right, well, in
Yes.
that case, please. Yeah, okay, well, in that case, could we ask the senior appellant, I suppose, to give her rebuttal first?
Yes.
Thank you.
Thank you, Your Honors. We would like to highlight that in the opposing counsel's argument, they mentioned how there had been a cluster of nodes, which is why the United States jurisdiction had been favored. In such a case, that would be in favor of our argument because the DIFC only had one singular node, and given that there are hundreds, there would be other jurisdictions which would have multiple nodes, at least over one, which would give it the substance. Thank you, Your Honor.
All right, short and sweet. Can we hear from the junior appellant, please?
Yes, I'll try and make it short and sweet as well. There's just 3 points that I'd like to make. The first thing is when they tell us that the state of mind of the individual shouldn't be taken into account, we say that's the reason why we're appealing. But we also question why they spend so much time talking to us about good faith and bad faith if the state of mind is not something that they were interested in. I think this is the first thing that's important. The second thing is in discussions of mistake, unilateral mistake is on behalf of one of the parties, but the majority of their case, they were focusing on mistake on behalf of Clevity, the platform, not mistake of Miss Rani, who is their client. Unilateral mistake has to assume that their client is the person who has committed this mistake. But thirdly, and this is according to Article 37.1. But thirdly, even if we were to be gracious and admit that, we would like to again further ask the question: if we look at 37.2, whether necessarily it was a mistake or an assumed risk and negligence, gross negligence, and we say that that is necessarily the case. And even in the absence of the glitch that they put a lot of their case on, even in the absence of a glitch in a scenario where there is only one trader, which is very plausible in the cryptocurrency world where there is hoarding of sellers, in that instance, her algorithm would have done the exact same thing. And that's why we don't think that in this instance, it was our client or Mr. Payne's sinister intentions. It was just business. We're very sorry if that business did not work out for Ms. Rani.
Thank you very much indeed. Well, look, I guess we judges better go and...
Your Lordship, I'm sorry to interrupt.
Of course.
Maybe Sir Robert. Maybe Sir Robert. Apologies. Am I audible? Hello?
Yes.
Okay. So maybe Sir Robert for the rebuttals. Okay. Your Lordship, the counsel for
the rebuttals are usually just the appellants, if I'm not mistaken.
So we have Sir rebuttals as well. We've clarified with the organizers, and we've reserved time for the Sir rebuttal.
Okay.
Okay.
Fine.
Maybe. proceed?
Yeah, of
Okay.
course, absolutely. I was just going to say one thing whilst it occurred to me, just for all of you. Like I said before, lawyers are always honest, but we're sometimes frank. Advocates never say what they think. They make submissions on behalf of their client. Yeah, so you never say to a judge, I think. I'm sure you do think that. We all know that, but you always say it's my submission that, not I think that. Okay.
Your Lordship, the
Sorry, please
opposite...
continue.
Apologies, the network's pretty lagged out, so I cannot hear in time. Your Lordship, the counsel for the opponents have failed to understand the principle of Article 5A1B. As I clearly stated earlier, even the presence of a single node would be sufficient for the gateway to be met, because the nexus is between the contract and the location and the performance. Therefore, even the presence of a single node would be sufficient. The reason why the senior respondent had mentioned that case was not because the cluster of the nodes or the location, the cluster or the number of the nodes. So it's only that this case had taken into account that the presence of a node is in favor of a jurisdiction, Your Lordship. So in that regard, regardless of the fact that there are 10 nodes, million nodes, NDIFC, or even a single node would be immaterial, because as long as there is a performance on that node in reference to a contract, that would be sufficient to maintain jurisdiction, Your Lordship.
Thank you very much.
Your Lordships.
Thank you.
In regards to a rebuttal for the respondent for the second round of appeal, Council would like to state regarding the Council did not talk about the error in clevity, but due to the error in clevity, the contract cannot be enforced, and hence there's no liability which is given to clevity. On the other hand, also, beta was programmed by Payne in such a way that in absence of any market activity, it will sell YAPL at a highly inflated price. And Payne took the opportunity that if there was no users in the platform, it would sell at a highly inflated price and being unjust and bring imbalance in the contract. Due to the error in clevity, the the opportunity was well handled and caused an imbalance, Your Lordship. This is in regards to the rebuttal, Your Lordship.
Can I just say thank you to all four of you for excellent, excellent performances. Secondly, can I just say we were so delighted to have rebuttals from the respondent, because from our point of view, anyone who is fighting for their client and saying, well, the other side's got a rebuttal, why can't I have one? If you don't ask, you don't get, and you should ask, because you're fighting for your clients. And finally, and I'm sure it's going to get a giggle from my co-judges, can I just say that the way that the rebuttals were just so precise, so succinct, you put real lawyers to shame. Normally, a lawyer stands up to make a so-called rebuttal, and you're still there an hour later. Whereas the way that you all four of you focused your points was fantastic. We obviously can't put you all through, but you were all fantastic.
Totally agree. Congratulations to all of you.
Thank you.
It really was our absolute pleasure to judge the semi-final. But I suspect, I don't know what time it is, and I'm in a different jurisdiction.
Yes, I suspect
somebody as well.
that, yes, we have to decide.
Right. Okay, so I guess shall we three go into the judges' room and talk there?
Definitely.
Okay, we'll do that. Thank you so much, everyone.
Thank you very much, everyone. Congratulations and best of luck for everything. Bye.
Okay. Bye.
Bye.
Bye.